relation to reduction of capital of a Hong Kong company, the change is a fundamental one. Before the new law, a company, it cannot reduce its capital basically without going through the court. But under the new law, the regime has now become much more flexible. The company may reduce its capital provided that certain conditions are satisfied. One is director standing by the solvency status of the company. The second is the shareholders approve such action. So the practical takeaway is that from an investor's perspective, when you negotiate your next joint venture transactions using a Hong Kong company, you may want to consider this reduction of capital as an exit. That means you may want to agree with your joint venture partner under certain situation, you may want to withdraw the capital out of the company. So this is something that could be possible for the way forward. In relation to financial assistance, again, in the old law, financial assistance was interestingly complex. Okay, it was illegal. Financial assistance made in contravention of the old law was void. Nowadays, with the new Companies Ordinance, financial assistance is possible. Basically, the law requires the directors to stand behind the solvency status of the company. As long as the company is solvent, then it is possible for the company to grant financial assistance, which means giving assistance in a monetary way to assist a purchaser to buy shares in that company. Because of this relaxation, it's actually possible for companies to make use of financial assistance if it is used legally and properly to facilitate merger and acquisition transactions. Reason being, as long as the company is solvent, let's say in a situation that you are buying a cash-rich or asset-rich company, you can actually make use of the assets of the target company to provide some assistance like pledging the assets to assist the acquisition of the shares. So it's just now possible, and we see that possibly this would help to facilitate a lot of transactions in terms of M&A transactions going forward. After all, the new Companies Ordinance is a brand new ordinance. It has 921 provisions, and it is one of the most complex ordinances in Hong Kong. So the Companies Registry has been given a lot of powers. We have yet to see how these powers will be exercised. And we have a lot of new provisions, new regimes. I think in terms of how these are implemented or how these provisions are interpreted, they have yet to be tested before the courts. As the new Company Ordinance has just taken effect, we believe that there is a process for the public to react to these changes. We also expect government departments like Inland Revenue Department and other regulatory authorities, they might issue guidelines and guide companies and clarify issues as to what are the impact from a tax perspective regarding these new changes. For other regulatory authorities like Hong Kong MA or SFC, they may want also to issue guidance note and clarification to clarify changes. In relation to the Hong Kong legal environment in general, we expect that the Companies Ordinance will take effect, although there's not a definite timeline for the time being. Also, another legislation, the Contracts Rights of Third Parties Bill, is now in the legislative process, which we also expect it to be finalized quite soon. So all these are also helping Hong Kong to be in line with the international legal environment standard.